Hello, welcome to Company and Partnership Law class. Today we want to look at Directors of Companies, which is Session 4 of Unit 3, Session Objectives. By the end of this session, you should be able to describe who a company director is, explain how company directors are appointed, and lastly, explain the 4 types of directors. Now, the question is, who are company directors? Now, the provisions of Act 992, specifically Section 179, subsection 1 of Act 992, provide that directors are those people who are appointed to direct, administer the business of the company. In other words, directors are people who are appointed or elected to control the affairs of the company. As we indicated earlier on, directors are appointed to direct or administer the business of the company. However, sometimes a person may act as a director. Meanwhile, he or she has not been appointed as a director. So, the Companies Code Section 170 of Act 992 also provides another category of directors. We have what we call a de facto director. A de facto director. When we talk about a de facto director, we simply mean that a person who has not been duly appointed as a director, but the person hold out himself or herself as director, or knowing allow himself to be held out as director of a company. So this is what you are saying. The person is not a director, or the person is not duly appointed as director, but the person hold himself out as a director, or the person being aware that he's not a director, allow other members of the company to hold him or her as such. In the case of Kumado v. Fruit Suppliers Ghana Limited, a person who was not duly appointed as a director, his name was used as a director on the letterhead of the company, and it was used to transact business. The company refused that contract will bound it, but the court gave ruling that once the person's name is on the letterhead as a director, he is deemed to be a de facto director, and hence any contract that has been entered with that particular letterhead, the company is bound by such contract. Now you have another category of director, which is the shadow director. With a shadow director, he too has not been appointed as a director for a company, but his directions or instructions, the duly appointed director feel that he is accustomed to. Now this is what you are saying. This shadow director has not been appointed or duly appointed as a director, but he gives instructions and directions to the main director, and as such, the main director feels that he has to obey that instruction or direction. This may be due to as a result of the person's experience, or the person may be a beneficial holder of the company, or the person holds majority of the shares in the company and he gives instruction aside. So the law will hold that person as a shadow director. In that case, whether you are a shadow director or you are a de facto director, you shall subject to the same liabilities and duties of a duly appointed director. It means that whether you are appointed or not, or if you have not been appointed, by you hold yourself out as a director, or you give instruction for the main director to follow, then you will be subject to the liabilities and duties of a person who has been appointed as a director in a company. This provision that we have just discussed is from Section 170, subsection 2 of Act 992. Now, each company is expected to have at least two directors, and it is provided by Section 171, subsection 1 of Act 992. Each director must have at least two directors. The law provides that where a company carries on business with less than two directors for more than 4 weeks, then the existing director, the officers who are aware of that defect in the company shall be liable to pay an administrative penalty unit to the registrar. Now, share qualification of a director. Section 174 of Act 992 deals with the issue on share qualification of a director. Unless otherwise provided by the constitution of a company, the law does not require a director to hold a share before the person can become a director of the company. However, if the constitution of that company requires that a shareholder or a director of a company must necessarily hold a share in the company, then the person must fulfill that condition. Other than that position, he will lose that position as a director. Now, let's deal with the appointment of directors. You should know that the first directors of a company shall be named in the application for incorporation. You remember when we were dealing with formation of company, we specifically said before you form a company, you have to comply with section 13, which states that a company shall submit or deliver to the registrar an application for incorporation. That is section 13 subsection 1. Then section 13 subsection 2 provide that the application should contain certain documents, so certain particulars. So the first directors of the company should be named or should be stated in that application form. You should also know that a person shall not be appointed as a director of a company unless that person has, before the appointment, made a statutory declaration subject. So this one is a key point, and it is one of the new provisions that Act 992 introduced as compared to Act 179. The director in question must make a statutory declaration and must file to the registrar that within the preceding 5 years of application, he or she has not been charged or convicted of a criminal offense involving fraud or dishonesty. If you recall, section 13, subsection 2, paragraph H also states similar points, that the person should not be charged with or convicted of a criminal offense involving fraud or dishonesty. So these are the elements: offense of fraud and dishonesty. Example will include stealing, defrauding by false pretense. Also, the person should not be charged with or convicted of a criminal offense relating to promotion, incorporation, and management of a company. Then you should also say that you have not been a director or a senior manager of a company that has become solvent. Sorry, that has become insolvent, or if the person has been, the date of the insolvency in the particular company. Here, what it means is that you should declare that within the past 5 years before the application, you have not had a directorship position in a company or a senior management manager position in a company in which the company has become insolvent, that the company is not able to pay its liabilities when it fall due. Now, if you have had such a position and insolvency has occurred, you have to state the date in which that insolvency occurred and the particulars of the company. A typical example is you can cite some of the financial institutions that were collapsed few years ago. So if a director from that company want to hold another directorship position in a year to form company, then the person has to state that position as well. You should also know that before you be appointed as a director of a company, you should be consented in writing. You should be consented in writing. It means that the fact that you have accepted to be acting as a director for the company, it should be in writing. And once this is done, it will be filed with the registrar within 28 days after giving consent. So when the promoters approach you to act as a director, you are required to write it to them if you like to occupy that position, to consent or agree to the fact that you act. And once it is done, within 28 days of filing or accepting the appointment in writing, the company will now file that consent with the registrar. This is provided in section 172 of Act 992. The constitution of a company may provide for appointment of a director or directors by a class of shareholders, debenture holders, creditors, employees, or any other person. What this means is that a company that has registered with its own constitution, the constitution may give certain rights or the powers of appointment and the removal of a director to a particular class, maybe class A shareholders or debenture holders, or even creditors, or sometimes it can be employees, or the constitution can name anybody at all to do that appointment. When such person is named in the constitution, it is only that person which can exercise that function. You now want to turn to qualifications of directors. The law does not provide for qualifications of directors, but what it provides is disqualifications of directors. So when we are dealing with qualification of directors, we just have to negate the point here. The law provides that the foreign persons are not qualified to be appointed or to act as a director of a company. So it means that if you are an infant, you are disqualified. Infant in this context is someone below the age of 18. Below the age of 18. Now, it means that if you are adult, you qualify to be a director of a company. A person adjudged to be of unsound mind. If you are adjudged to be of unsound mind, you are disqualified. So it means that if you are adjudged to be of sound mind, you qualify to hold the position of directorship. Now, note the fact that someone is of unsound mind is for the court to determine, but you can't just look at someone's face and say you are of unsound mind. This cannot be done. It must be determined by the court. A body corporate cannot be a director for a company, like one company cannot be a director for another company. Also, a person who is prohibited from being a director or promoter or being concerned. So if you are prohibited or not barred from becoming a director of a company, unless that disability is removed, you cannot become a director of any company. You should also note that undischarged bankrupt cannot hold the directorship of a company. However, if the bankrupt has been removed or if the court has granted a leave for you to act as a director, you are entitled to hold that position as well. Now, there is no academic qualification for holding directorship position. However, it is ideal that before you can hold the position of a directorship, you should have some level of experience, either through formal education or informal education. Types of directors. Now we have the substitute director, alternate director, executive director, managing director. Let's start a discussion with substitute director. Under section 180 of Act 992, the law provides that, except as otherwise provided by the constitution of the company, a company may allow for the appointment of substitute director. That substitute director is a deputy to the named director. The substitute director shall not be counted as a director when you are dealing with the maximum or the minimum number of directors of the company. However, he will only be counted as director when you are looking for a quorum in a meeting. A substitute director may attend a meeting or meeting of board of directors or committee of directors. However, the substitute director will not vote when the main director is at the meeting. Now you have alternate director. Section 181 of Act 992 provide that unless otherwise prohibited by the Constitution, a company may appoint an alternate director. Now, the alternate director can be appointed when the main director will be absent to perform his function for more than 6 months. Then he will appoint another person. So the person may act for only 6. So as I was saying, the alternate director can only act for 6 months. That's where a director is unable to perform his function or he's traveling out of the country for maximum of 6 months. Then he will appoint an alternate director. Such an alternate director can be an existing director or any other person. If it's any other person, then it is subject to the board's approval. And this was heard in the Okujote's case. The alternate director is an officer of the company and not the agent of the person who appointed him. We also have executive director. Executive director is a person who holds a position of profits under the Companies Act, under the constitution of the company, other than the position of an auditor. So you have to note that one as well. You also have the managing director. The directors may from time to time appoint one of their members to act as a director of the company, managing director, and who directs the affairs of the company. Once the person ceases to be a director, he ceases to be a managing director as well. By way of summary, we have learned that a person prior consent in writing is required before his appointment as a director. I've also explained substitute directors, managing directors, executive directors, and you have dealt with the qualifications of directors. Thank you.